Hello, 1 2 3 check. Hello, 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 check. Hello, 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 check. Hello, 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 check. Hello, check. Hello, 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 check. Hello, 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 hello. Hello, hello, hello. 1 2 3 check. Hello, 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 hello. 1 2 3 check. Hello. Hello, hello.
Jai Jagannath to all. Good evening. Today is our sixth law lecture on the topic Indian Constitution, its doctrinate ethos, remedial structure, and judicial sustainability. It is going to be delivered by our Honorable Sri Justice Haris Tandon, sir, Chief Justice, High Court of Orissa. Sir, I request you to please come to the podium, sir. I request our President, sir, to please come to the dais. And also I request our Vice President, sir, to come to the dais. I welcome all the dignitaries. I welcome all the honorable judges of Odisha High Court, all the senior advocates of Odisha High Court, and all my elder brothers, sisters, and brothers. And I call upon our uh, Mr. Sohagya to hand over a bouquet of flower to our honorable Chief Justice, sir. I request our executive body member to please hand over a bouquet of flower to our President, sir. I request our executive body member to hand over bouquet of flower to our Vice President, sir. As all of you know that this month we celebrate our Constitution Day on 26th November. So definitely it is a very befitting topic that to be delivered by our Honorable Chief Justice today. So it will be a, a great tribute to that particular day. With this, I call upon our President, sir, to start the proceedings. Thank you.
Jai Jagannath. Good evening to all. My Lord, the Honorable Justice Harish Tandon, Chief Justice of Orissa High Court, Honorable Judges, Vice President Mr. Siddharth Das, Secretary Mr. Abhijit Patnaik, other office bearers of our Bar Association, London Senior Advocates, London members of our Bar Association, London Registrar General, and other officers from the registry, ladies and gentlemen. It is a great privilege that my Lord Honorable Chief Justice will address us on the topic. I will not repeat the topic because my secretary has already told about the topic. When he requested my Lord the Chief Justice to deliver a speech in our law lecture series program, not only that he appreciated our attempt in arranging such law lectures, but also his Lordship happily agreed when we asked his Lordship to choose the topic of his choice. His Lordship was gracious enough to say that he is agreeable to speak on any topic that may be chosen by us. We took the opportunity and chose the topic because same is the backbone of judicial evolution. We are sure that His Lordship and the Honorable Chief Justice, with his tremendous grip over the law and his par excellence, would enlighten and educate us on the topic. We are highly obliged to His Lordship for giving kind consent to deliver law lecture. It is a great privilege and profound honor and express gratitude to His Lordship to share his knowledge and valuable insights and perspective in his speech on the topic. We are eagerly waiting to listen to His Lordship's insight and expertise. With this, I welcome Honorable Sri Justice Harish Tandon, the Chief Justice of Orissa High Court. Thank you. And I request Honorable Justice Tandon to speak.
Good evening to all of you, my brother and sister judges who have spared time to listen me on that particular topic. I am really thankful to them. The other senior members of the bar who have also taken out a time to attend this particular symposium or law lectures, as I call it, I would say sparing their valuable resource persons who must be waiting in their chamber, the president, the secretary, and the vice president, the other office bearers of the Orissa Bar Association, High Court Bar Association, my beloved junior members of the bar. I do not know whether the research assistants are also here to attend this program. So I mean them also, ladies and gentlemen. As in our state, we start by remembering the name of Lord Jagannath. So Jai Jagannath to all of you. Uh, it is really a daunting task for me to stand before an intellectual and elite class of peoples who are well versed with the intricacies of law, and I feel myself unfit to teach law to them. As we all know, we are all the student of law and always learn on a daily basis something which really comes new, something it brings a new idea, sometimes even a new interpretative tools are adopted by the court, by the courts, the bench, or the members of the bar. When the president of the bar association and the secretary both came to me and wanted me to be a part of the 6th series of law lecture which they decided to organize, I was very overwhelmed with this, because this is an opportunity to interact with you, to be a part of you, and to remain with you and to connect with you. So I readily accepted this proposal, and the topic was already chosen by him. What he says is not correct. It was already chosen by him, and he says that this is what a topic we have chosen. If you want any other topic, then we can refurbish those topics. So I said, once you have already decided, with the predetermined mind, if you have come to me, then it is not definitely a good thing that I should impose something on you. So I decided to speak on the topic. I must be very candid and very clear in this regard, that definitely my address would not be on a legal principles or anything which really comes therefrom. I will be definitely, when one of the word which is used in this topic is doctrinate ethos. My entire deliberation would be to decipher what is the ethos of the Constitution. I may go back to the era where the formation of a constitution or even a constituent assembly was at the rudimentary form or a rudimentary stage. And as a law student, as a reader of a law book, my attempt would be to cull out such ethos, which in my humble opinion makes the foundation of our constitution. I have been assigned to deliver lecture on an important topic, Indian Constitution, is its doctrinate ethos, remedial structure, and judicial sustainability. Definitely, this is a sixth law lecture organized by the association to commemorate the tireless work of our forefathers, whose invaluable contributions in achieving the freedom and giving a constitution to the people of our country. The journey was not on a terrain filled with the rose petals, but on the thorn as the Constituent Assembly was constituted during the British era. From the first day, that is the 9th December 1946, when the Constituent Assembly met, it took more than 3 years to bring a living document, which we now embrace as Constitution of India. Even it took more than 8 months and 6 days after after we achieved freedom. A little prelude to a historical movements and the laws to be imposed by the Britishers are required to be recapitulated to understand the constitutional ethos, which is coined as doctrinate ethos in the topic chosen by the Bar Association. The major constitutional development implanting the seed in making a constitution can be traced when the British Parliament introduced and promulgated the Government of India Act 1935. The said act propagates the establishment of a federation under the crown in the name of the Federation of India, consisting of two provinces. One, the provinces called the governors' provinces, and the Indian states, which has acceded or to be acceded in future to the federation. It is often said by the critics that the provisions contained in Government of India Act 1935 are largely embodied in drawing up the constitution and was even voiced when the draft constitution was introduced by Dr. Ambedkar. As we all know, the great man who in his usual fairness and in a commitment towards drafting the constitution replied, may I quote, as to the accusation that the draft constitution has produced a good part of the provisions of the Government of India Act 1935, I make no apologies. There is nothing to be ashamed of in borrowing. It involves no plagiarism. Nobody holds any patent right in fundamental ideas of the Constitution, unquote. Look what's the splendid words he said during this debate of the Constituent Assembly. Having a stand on the firm commitments which he had, and to his remarks which I just read, Dr. Ambedkar further highlighted that the Government of India Act 1935 did not provide for any fundamental rights or directive principles of the state policy. And social and economic drawbacks of India could only be truly felt by the Indians. The Constitution, therefore, addresses the multitude of problems at various levels of stratified society that too, after obtaining absolute freedom from the foreign dominion. There has been a constant debate on the first article of the Constitution, as different countries have varied perceptions. Dr. Sarvapalli Radhakrishnan, after his election as the first permanent chairman of the Constituent Assembly, in his usual intellectual eloquence, attempted to define the Constitution as, I quote, a Constitution is a fundamental law of the nation. It should embody and express the dreams and passions, ideals and aspiration of the people. It must be based on consent of all and respect the rights of all people who belong to this great land, unquote. From such profound words and expressions, one can reasonably fathom the clarity from the language which inexorably leads to clarity of thoughts. The two expressions which I have culled out and dissected as the doctrinate ethos of the Constitution, that it's a dreams and the aspiration and the ideals, the dream and the passion, and ideals and the aspirations appears to be a foundational ground in the debates at the Constituent Assembly, which, in my opinion, is repository of the commitments which the members of the Constituent Assembly owe to the people of the country, and bring the documents involving the representation of the various sections of the society and the people at large. If I tersely put in a simplest language, it is a collection of the rules for official behavior for the reason that every action of the government is legitimate if it is permitted by the Constitution. The journey of making a Constitution, as I already said, was not smooth, as every sentence or expressions used in the draft Constitution was deliberated upon, including the incorporation of a preamble as a part of the Constitution. The members of the Constituent Assembly suggested several amendments to be brought, and during the interaction, the dissent and the discontent can be manifestly envisioned, but ultimately it was adopted as a part of the Constitution. In Keshwanand Bharti versus the State of Kerala, reported in 1973, Volume 4 SCC, page 225, it is held by the Constitution bench that the preamble occupies a sense of right and embodied in a solemn form all the ideals and aspirations for which the country has struggled during the British era. It represented an amalgam of schemes and ideas from different constitutions of the countries, and therefore meant to embody in a very few and well defined words the key of understanding of doctrinate ethos of the Constitution. This leads to an amendment in the preamble by adding the word social in 42nd Amendment in 1976. Our Constitution is not truly any traditional pattern of a federation, but based on a theory of withdrawal or resumption of all powers of the sovereignty and based upon to the peoples of the countries. And above all, the distribution of powers between the union and the states. In many respects, it recognizes somewhat independence of the state in many aspects, which are further highlighted in the six-judge bench decision of the Supreme Court in case of State of West Bengal versus Union of India, AIR 1963 Supreme Court 1241, where the apex court recognized the distribution of powers between the union and the state, where each in its sphere are coordinate and independent of other. But when the matter relating to a national importance in which the uniform for policy is desirable in the interest of the state, the authority is entrusted to the union and the matters of local concerns remain with the state. We commonly know that this particular judgment is a judgment between the Chief Minister B.C. Roy and the Prime Minister Jawaharlal Nehru. Though this came because there was a conflict in between the interests of the state and the union. There has been a constant cry to find the true meaning and the purpose as to whether the constitution is federal or quasi-federal in nature, and whether it can be termed as a basic structure of the constitution. Even in Keshwanand Bharti's case, the majority view has not treated the federalism as a part of the basic structure of the constitution, which is further agitated before the seven-judge bench in the case of my brother hailed from there, State of Karnataka versus Union of India, AIR 1978, Supreme Court, page 68, where it is held that the India is undoubtedly a union of states. Whether we describe it as a federal or quasi-federal, one cannot even blind one's vision to the stark reality that India is a union of states. And therefore, the Constitution contains a carefully conceived demarcation of powers, legislative and executives, between the central government on one hand and the state on the other. As mentioned above, the unique feature of the Constitution is the fundamental rights conferred upon every citizen of the country, which is inviolable but circumscribed by the established procedure of law. It imbibes within itself various facets of right, which is ingrained and inherent in every citizen, which I do not intend to delve much deep, as the audience are well versed with the nuances of the fundamental rights guaranteed by the Constitution, and its preservation and protection is one of the ardent duty, not only of the court, but also the members of the legal professional fraternity. When the topic includes remedial structure and the judicial sustainability, it immediately resonates the access to justice and protection of the right of the citizenry so guaranteed under the Constitution, and its remedial measures under Article 32 and Article 226 of the Constitution of India. The aforementioned articles provide a constitutional forum which is robust, evolving, susceptible to be molded in pursuit of enforcing the rights in the expectations of the peoples against the state authority or the institution in the field of public law. Article 226 of the Constitution ensures and oversees that the rule of law is not undermined or subverted. And above all, the Constitution is supreme. Although it reflects and traces its origin from the powers exercised by the British court in issuing the prerogative writs, where the action of the sovereign is under the judicial scrutiny, but the framers of the Constitution profoundly believe that the restrictions so perceived by the British Council or British courts should not deter the constitutional court of the country in preserving and protecting the fundamental rights of the people or other constitutional rights guaranteed under the Constitution. The coinage of the word judicial review have its source from England and other similar jurisdiction exercised by the courts of the other countries, where the judicial reviews are restricted to the executive or administrative action or inaction. But our legislation, where the statute enacted by the parliament is also tested on the anvil of the constitutional ethos or its provisions. The constitutional courts in India are vested with enormous power of declaring any legislation ultra vires to the constitution, either because the legislation is incompatible with any constitutional provision, but also has transgressed into a fields not assigned by the constitution. Interestingly, the debate in the Constituent Assembly on a draft article concerning Article 226 of the Constitution of India was only restricted to two members, that is Mr. H.V. Kamath and Dr. Bakshi Tek Chand, when they proposed certain amendments to be brought in the draft articles. Mr. Kamath suggested that instead of word writ, the expression to issue such directions or orders as it may be considered necessary or appropriate should be incorporated. Mr. Kamath was of the view that the High Court judges are well equipped to decide a particular writ and what orders to be passed, as no restrictions or inhibitions should be ingrained in exercise of powers conferred under Article 226 of the Constitution. Interestingly, Dr. Bakshi Tek Chand deferred and proposed no changes to be brought in the draft article, and it is worth reading his remarks, what he said. I quote, "These are the writs which I may remind the House have been among the greatest safeguards that the British judicial system has provided for upholding the right and the liberty of the people, and it is very necessary that it should be incorporated in our Constitution." Unquote. Dr. Ambedkar, while supporting the incorporation of Article 32 and 226 of the Constitution, reminded the Constituent Assembly that such provisions are in effect the heart and soul of the Constitution and provides for access to justice to a large section of the people of the country, including underprivileged, and conferment of powers upon the High Court to issue writs, which shall also ensure that the citizens are not unnecessarily burdened with the cost that they have to be in approaching the apex court under Article 32 of the Constitution. Though there was no debate on a monetary aspect concerning the access to justice, but there was a discussion when the article restricts on the parameters of the territorial jurisdiction. The apex court, in one of its earliest case, rendered in Election Commission of India versus Saka Venkata Subba Rao, reported in AIR 1953 Supreme Court 210, held that the seat of the authority or the government against which the writ is sought to be issued must have a seat within the jurisdiction of the High Court, which again open a conflict when the action of the government or authority seated outside the territorial jurisdiction is sought to be challenged. More particularly, the action concerning the Union. Such difficulty was further adjudicated by the apex court in a subsequent judgment rendered in case of Lieutenant Governor Khajur Singh versus Union of India, in 1961 Supreme Court 532, where the apex court held, I quote, "The concept of cause of action cannot, in our opinion, be introduced in Article 226. For by doing so, we shall be doing away with the express provision contained therein, which requires that the person or authority to whom writ is to be issued should be the resident in or located within the territories over which the High Court has jurisdiction." Unquote. It is true that this may result in some inconvenience to a person residing far away from New Delhi, who are aggrieved by some order of the government of India as such. That may be the reason for making a suitable constitutional amendment in Article 226. This particular observations, which was made in that particular celebrated judgment, led or invited the 15th Amendment of the Constitution, imbibing the concept of the cause of action, either wholly or partly, irrespective of the seat of such government or the authority. The concept of cause of action, wholly or partly, in my opinion, is borrowed from the codicil procedure, where the jurisdiction of the courts largely depends upon the accrual of the cause of action in its entirety or in part. Even a minuscule part of the cause of action, if arisen within the territorial jurisdiction of the court, shall confer the jurisdiction in deciding the cause or the issues, and therefore it expanded the horizon of the jurisdiction exercised by the High Court to meet the aspirations and the ideals of the people of the country to address their grievance and seek the redress before the High Court. The consistent pattern of evolution from the various decisions enunciated by the apex court exercising the power of judicial review was perceived as a vanguard of a social revolution in 60s, accelerated till mid 70s and swinging in back into latter part of 80s. One of the significant and dynamic steps which the writ court evolved was a concept of a public interest litigation, opening the doors of the constitutional court for those who suffer from poverty or a social backwardness which inhibited the access of justice, to be fostered or agitated through a representative process by the public spirited citizens. It is a paradigm shift from a traditional notion of a private law domain where the contracts and the tenders floated by the public corporations were challenged, but infuse the public law principles where the state statutory corporations or the government companies are found to have treated the person unfairly and arbitrarily. It has all along been a consistent view of the Constitutional Court by entrenching the principles that the power of judicial review is concerned with the judicial making process and not the decision. And it is no longer misnomer that the every action or the decisions are tested on the anvil of fairness, reasonableness, and above all, the perversity perceived in the action or the decision of the authority. As commonly knows that the law is not static but dynamic, which also applies in case of a dispensation of justice, and the courts have not shied away in impinging the decision of the authority by adopting many substantive principles like abuse of a discretionary powers, malafide, exercise of powers, as well as the transgression of the jurisdiction. As we commonly use the expression extraordinary jurisdiction exercised by the writ courts, the coinage of the said expression sees its origin from a five-judge bench decision of the Supreme Court in State of Uttar Pradesh versus Dr. Vijay Anand Maharaj, reported in AIR 1963 Supreme Court 946, wherein it is observed that it is an extraordinary original jurisdiction and not the original jurisdiction as conceived by the latest patent or the Code of Civil Procedure or any other forum created by the statute in an ordinary process of legislation by the union or the state. Till the early 70s, the Supreme Court and the High Courts were exercising their respective writ jurisdiction as an extraordinary original jurisdiction, but the 42nd Amendment, having brought in 1976, tacitly clipped when Article 323A and Article 323B was introduced, which brings the concept of tribunalization and the original power is diverted. Immediately, the challenge was made to the Supreme Court, where the Supreme Court was of the view that the word Supreme Court should be deleted, but upholds the validity and the constitutionality of the said amendment. Interestingly, the Andhra Pradesh High Court was also considering the virus of the 42nd constitutional amendment and was of the firm view that it purports to oust the jurisdiction of a high court under Article 226, and it was beyond the amending powers of the parliament where the recourse under Article 368 was taken, as Article 226 of the Constitution is a basic structure. The challenge was made to the Supreme Court by the state, which was tested by the seven-judge bench in case of L. Chandrakumar versus Union of India, reported in AIR 1997 Supreme Court 1125. Holding the concept of a basic structure theory propounded in Keshwanand Bharti's case, but instead of declaring the constitutional amendment to be ultra vires, propagated that the order of the tribunal can be tested before the division bench, either under Article 226 or 227 of the Constitution.
Since thereafter, the remedial structure provided under Article 226 of the Constitution of India is being sustained, and the restrictions or obstacles sought to be created have been removed under the judicial fiat, and the ideals and aspirations of the citizen of the country in reposing confidence in the judicial system is preserved from time to time. The powers, the jurisdiction, and the scope of the judicial review is expanded and tailored in commensurate with the need of the people, imbibing within itself several facets of the dispute on well structured legal parameters. It would be a sheer academic if I mention the judgment rendered by the constitutional courts of the country on the jurisdiction, scope, and the exercise of powers, either under Article 32 or the 226 of the Constitution, as I feel that the audience, being well versed with the nuances of law and have acted as a crusader in rising to an occasion when the decision or action or inaction of the government or authorities are challenged before this court in pursuit of justice. The remedial measures and the sustainability can never be undermined nor abridged, as in my opinion, any converse view would be opposed to the ideals and aspiration and dreams and passions of the citizens, which in my opinion is the doctrinate ethos of the Constitution. I am thankful to the Bar Association who provided me the platform in expressing my views. Thank you. Jai Jagannath, Jai Hind.
Thank you, sir, for delivering such a enriching and enlightening us on this topic. My lords, we are grateful for gracing this occasion. And my lord, this entire graphic work that has been displayed through our all this series of lectures is because of our brother, Mr. Sanjay Kumar Mahapatra. Please give him a big hand, please. Thank you very much, Sanjay bhai. Now I request our Vice President, sir, to give the vote of thanks.
Very good evening, everybody. Esteemed Chief Guest of this function, Honorable Mr. Justice Harish Tandon, the Honorable Chief Justice of Orissa High Court, Honorable Judges of the Orissa High Court, respected Sri Manoj Kumar Mishra, Senior Advocate, Learned President of Orissa High Court Bar Association, Secretary Sri Abhijit Patnaik, and all other office bearers of the High Court Bar Association, learned senior members and learned members of the bar, my dear colleagues, brothers, sisters, ladies and gentlemen. The High Court Bar Association is continuing its Madhusudan Law Lecture series from 8th May 2025. The sixth law lecture held today on the topic Indian Constitution, its doctrinate ethos, remedial structure and judicial sustainability. It is a great honor and privilege for me to extend the vote of thanks on this occasion. I, on behalf of the High Court Bar Association and the entire legal fraternity, extend the vote of thanks to all the dignitaries, chief guest and speaker on the dash and of the dash for gracing and making this seminar really successful. I would like to thank Honorable Sir Justice Harish Tandon, the Honorable Chief Justice of Orissa High Court, for his inspiring and illuminating words and profound thoughts on the topic and for making this gracious presence for his busiest schedule to grace the occasion and sharing his valuable thoughts on the interesting yet exhilarating topic. The Indian Constitution is not merely a legal manuscript, it is the moral compass of a civilization that chose democracy as its destiny. Every right in Indian Constitution finds its living force in the remedies it promises. Justice in India begins where the Constitution ends, in action. Your valuable words expanding the scope of the Constitution will inspire the advocates to fight for the justice. Thank you very much, my lord. I would like to extend my heartiest thanks to all the dignitaries, guest honorable judges, officer of the registry, learned senior members, and the learned members of the bar, print and electronic media for their kind support, participation, and gracious presence to make the symposium successful. Finally, I thank all of you present here for making this function a grand success. With these words, I conclude my vote of thanks. Once again, I thank you all. Jai Jagannath.